step out of the courtroom. He was also a visionary judge, one who seamlessly embraced technology and modernization, recognizing that the administration of justice must evolve with the times. On a personal note, I've had the distinct privilege of appearing before His Lordship's bench on a handful of occasions, first as a junior lawyer seeking accommodation, and later in my independent practice. What stays with me to this day is the absolute certainty that every single counsel would be heard and every single matter would receive genuine and thoughtful consideration. To a young lawyer, appearing before him was never just an assignment to be argued. It was a masterclass in fairness, patience, and judicial discipline. This evening, we have the rare privilege of hearing from a legal luminary who has mastered our noble institution from both sides as a highly respected member of the bar and then as a distinguished judge of this court. Ladies and gentlemen, please join me in extending a warmest, most resonant welcome to Justice P.B. Suresh Kumar.
Good evening, distinguished members of the KHCAA and my fellow advocates. It is a privilege to introduce our distinguished speaker, Justice Shaji P. Chali sir, whose career embodies professional excellence, judicial integrity, and dedicated public service. Justice Chali enrolled as an advocate in 1986 and went on to build a highly respected practice before the Kerala High Court. Over nearly 3 decades at the bar, he appeared in a diverse range of cases spanning from constitutional, civil, criminal, banking, company, and consumer law, earning the confidence of both the legal fraternity and the courts. His leadership qualities were recognized when he served as the president of the Kerala High Court's Advocates Association. In April 2015, he was elevated to the bench of the Kerala High Court, and in 2017, he was appointed a permanent judge. During his tenure, Justice Chali contributed substantially to the development of jurisprudence in areas including constitutional governance, administrative law, environmental protection, local self-government, and public accountability. His judgments are noted for their clarity of reasoning, practical wisdom, and fidelity to constitutional principles. Beyond the substance of his decisions, Justice Chali earned widespread respect for his industry, courtesy, and balanced approach to adjudication, qualities that strengthen public confidence in the administration of justice. Following his retirement from the Kerala High Court in 2023, he has continued to contribute to the legal profession, bringing to bear the insight and experience gained over a distinguished career at both the bar and the bench. It is therefore a great honor for us to have with us today a jurist whose professional journey reflects the highest traditions of the legal profession, a jurist whose career has traversed the bar and the bench and continued public service. Ladies and gentlemen, please join me in welcoming Justice Shaji P. Chali sir. Let's also welcome our senior advocate, M.I. HARIRAJ sir, for his gracious support to our Wednesday club and all our discussions. Let's have a round of applause. Now over to our moderator, HARIRAJ sir.
Good evening. I first walked into this court hall as a lawyer in the year 1999, along with Shalina and a huge lot of lawyers. That point of time, there were very elderly seniors like Kelnambiar sir and SVS, and then there were lawyers, what we call as the middle order batsmen. And the people who sit on my sides today are those, two among those. I'm very sure in this hall there exist a few lawyers who would have definitely seen them in action as lawyers, both Suresh sir as also Chali sir, from whom the people like me has literally watched and learned. And it's a pleasure to get to cross-examine them today. And usually lawyers make very difficult witnesses when it comes to cross-examination. I will try to make it as simple as possible. And I am also sure that most of the people sitting over here know their career as lawyers more from the reference speeches, the speeches as at the full court references when they were either elevated or were demitting office. Of course, there are a few who know it otherwise also. I see them nodding their head. But for the benefit of those who are new to this, who have seen you probably only as a judge and then as a lawyer who has started practice in the Supreme Court, can you start with explaining how were your initial years at the bar?
Hello. Am I audible? Good evening to one and all. It's almost 1 year since I retired. It's a pleasure to be here with all of you for this function. I'm grateful to the organizers for their belief that an interaction with me on various aspects of legal profession would benefit the young lawyers. Of course, this is an interactive session. I am subjected to as indicated, the cross-examination. Of course, I am willing to do so. But I would request you to just disagree with my views also, if you disagree, and then share with me your thoughts so that we can correct it later, so that I can correct it later. With this, let me just answer the question. I'm basically from Kollam district. I hail from Kollam district. My father was a lawyer there. I was with my father for about a year. Then it was his wish that I should shift my practice to the High Court. I never wanted at all to come to the High Court at all, because I was comfortable with the practice there in the Kollam district center. I joined the office of late senior advocate Sri P. Sukumaran Nair. As I indicated in my elevation speech, is also in the reference speech, that was the turning point of my career. He was an embodiment of integrity, a senior lawyer who meticulously prepares its brief. And I was with him for about 4 years. During that period of 4 years, his instruction was not only that I should study and prepare the brief that are entrusted to me, but also prepare and study the brief that he argues. Late Justice Thotathil Radhakrishnan was my colleague there in that office. I was asked to prepare the matters which he argues also. So for about 4 years, I had the immense opportunity to prepare large number of civil matters, not for arguing, for aiding them while they argue the matters. In the meanwhile, it so happened that, to be very frank, from Kollam there were not much lawyers in the Kerala High Court. I was getting a lot of work for the mere reason that I am attached to. I was attached to senior advocate P. Sukumaran Nair. So 4 years, in the span of 4 years, I was with him and I studied. I don't remember to have argued much matters, but again, I remember to have studied every matter in that office. And meticulous preparation was the hallmark of my senior. Then I was asked to meticulously prepare, in the sense, even when he does not require my aid, he was very particular that I get I am able to comprehend the real issues arising in every matter. I am underlining that, no, as a junior lawyer, what you are supposed to, how do you, I've been given a few set of questions and all, and I have, one question I still remember. What is, the question is as to how do you judge as junior lawyer? I have a simple answer. I have been telling to every law student who comes to me. The simple answer is that if you are able to comprehend the real issues in a case, correctly comprehend, then the halfway is through. So then it was an opportunity. It was by accident I happened to be there. By accident, because I was there, I was getting work, and then I became independent. And at that point of time, I was not that confident to become an independent, but again, with the support of my erstwhile senior, I started. This is the beginning. And then slowly things have fallen in place, and then by grace of God, I could handle a lot of matters. Till 2009, 2011, fortunately I was elevated, and then I got little more recognition, respect. Then I started attending a few matters in the Supreme Court also. It was while so that I was elevated. This is in brief my background.
Thank you, sir. It's a problem when you share the questions that you have prepared to a witness in advance. Some of the answers are already run on, short of questions over there. Also, I'll shift to Charlie sir for the question to him. So, unlike our first speaker, you are a first generation lawyer, if I understand it rightly. How different is it, is your journey? Because when compared to somebody who has the network connection and the background, how do you rate and how do you look at your initial years at the bar?
First of all, audible am. First of all, let me thank the bar for giving me this opportunity, because after retirement I have not come to the bar. In fact, to this hall. I was attending function definitely in our auditorium, various functions I have attended. I am thankful and I am happy to be back with you to share my thoughts. Hari said that we are prepared. In fact, the questionnaire was given to us. But I would say, I called Suresh yesterday night and said that we don't have to prepare anything, because it's general topic, how do you enjoy your initial ages, time as a lawyer. To begin with, I am a first generation lawyer. My father was a small-time planter, and basically farming activities we were have. Some of them were businessmen, some of them were government servants, some of them were a few other officers, civil servants and all. But ultimately, I would say that it was a zero litigation family. My family did not have any litigation at all, either within the family or outside. So to start with, my father was asking my father's elder brother, who was basically both of them were Panchayat presidents in different areas. My father was in Calicut district, my father's elder brother was in Ernakulam district, Manid. Both of them were Panchayat presidents for about 15 years, the first Panchayat. So that they were discussing how I am going to get cases, as a first generation lawyer. So I started, then I searched for the office. There was nobody to guide me actually. So I searched for the office. Finally, somebody told me that you meet M.V. Joseph, who was basically handling, labor matters, and used to go to the Workmen's Compensation Court. So I joined him. And I used to go to all courts, Workmen's Compensation, Payment of Wages Act, Labor Court, Industrial Tribunal, and all those things. There were a lot of cases for him, middle management as well as labor side. So I got a lot of opportunities while in his office to examine witnesses. To begin with, I'd say 10 days I started examining, which is not that difficult, Workmen's Compensation was at management side. A deputy labor commissioner sitting, you can ask any questions like from the management side. There was no problem at all. So I got opportunity, And I became fascinated to cross-examination like that. So even though I became a High Court lawyer, I'll tell you till my last breath, till I became a judge, I used to go to regularly to the lower court. When I started, I used to go to Tahsildar, I used to go to government secretaries, I used to go to industrial, this exemption applications, lot of cases, sales tax exemption, authorities like that. So that I was sure that I must remain in this profession. I must do continuous work. My attention should not be diverted to anywhere. So I started picking up cases, small cases, may not be, ultimately when you look at it, you must not have received any money. But I believe what I have earned is knowledge, legal knowledge. Many of them came to me when I became a judge. So it is embedded somewhere in your brain. I am sure about it. So, many cases, many aspects, I might have dealt with only once or twice. But several cases came to me, I know that I know this. To look for law, I know TP Act or Specific Relief Act, you look there. So it's embedded, definitely embedded somewhere. But never bother to take a small case. Forget about the money. What you gain is knowledge in law. You will become acquired with provisions of law that will help you in future. Now I continued in Joseph Sir office 1 year. Then I got an offer from KL Narasimhan, who was Justice Paripurnan's brother. He was basically an engineer, but very passionate in law. So while working as an engineer in Water Authority, he used to handle, everyday advice hundreds of, people, giving them, making them representations and all that. So he resigned and started working. So he asked me, he was one of my cousin's close friend. So he asked me, can we start an office? I'll come there for 2 days in a week, Monday and Tuesday. If you can manage, I'll take that office. So we took an office in Kerala Times building and started there. Used to have good work, and in the sense it had criminal, civil, writ petitions, everywhere, income tax tribunal, and he had lot of association with those senior lawyers coming from Madras to the income tax tribunal here. So I got opportunity. He used to be here only for 2 days, Monday and Tuesday. So I got sufficient opportunity to prepare, and argue cases. Like that, I remember the first file hearing matter I argued with Justice Patnabhan in 1989, 3 years after I enrolled. That was a case concerning this 112 paternity of child. It was a person met with an accident and he came from Singapore to here for treatment. If the child's birth is taken into account, it was the 280th day when he landed. But the evidence was that man was shifted from the aircraft to the hospital in a stretcher. So that it was a very interesting case. I remember still he warned me, don't read that doctor's evidence because he's so artificial. He told every dates after 4 or 5 years in the trial court meticulously. That means he was tutored. Don't read, you read the other evidences. Ultimately, I succeeded. That's a reported judgment. 89-1 KLD, that's a reported judgment. Like that, I got opportunities from Narasimhan's office also. I got lot of opportunities. I had lot of connections here. I must tell you that I came here at the age of 4 to Kochi from Mulamdirthi. I carried on my studies all in government institutions, SRV Government School, then Maharajas College, then in Government Law College. So that I had mixed relations. Very poor people from the social strata as well as very rich people. Because those days government institutions used to be like that, not like this. If you now enter, government colleges, you will find, you will not find that mixed crowd there. Because a lot of educational institutions other institutions have come. So I enjoyed like that, and due to my relationship I had in Kochi for long, people started giving me small work, to begin with. 2 or 3, 4 years, I started picking up work in High Court. And then 7 years I was with Mr. KL Narasimhan. Then somebody, Mr. NCV, the founder of IAM, and his father was a district judge, retired and came there. Still I continued with them for 2 years, though became familiar with Senior Advocate Mr. Narasimhan's work. Then I left and started my own practice. Like that I enjoyed, throughout my journey as a lawyer. Thank you.
Thank you, sir. Sir, it is usually said that a lawyer is born the day when his senior is accidentally absent. And that is when you slowly grow out of the shadow of your senior or father or whoever was guiding you and mentoring you. How do you look back and see those occasions when the small opportunities that trickle down? Probably at that point of time it was more of a headache than anything else, but now looking back, probably those are the decisive moments which made you strong in the career.
Fortunately for me, I was getting opportunities. I must thank Almighty God. I was getting opportunities from day one. As I indicated, my senior used to encourage to argue a matter. Even when he is there, he wanted all the juniors to just prepare and argue. By the time I joined his office, it was almost in the evening of his life, and then he was enjoying mainly guiding us, to be very frank. So I didn't have to wait for an opportunity for an accident, and I was getting opportunity, to be very, very frank. Only thing is that on account of large quantum of work which I was required to handle, I often feel that I am not doing. I often felt that I was not doing justice to the work. So I didn't have to wait for opportunity. I never had that problem at all.
As I told you, I think I've answered this when you asked me the first question. Like that also, I also got a lot of opportunities from the beginning in the trial court as well as, in the high court. They were very liberal. And when I asked MVO sir, after the labor court work, can I come to the high court? And they said, you read 1 or 2 files and prepare it and then come there. So I also started getting, opportunity to argue the matter before the court while with Mr. M.V. Joseph as well as Mr. K.L. Narasimhan continuously. It's not a doubt about it. See, I started picking up work. I'll tell you one incident. I was traveling to Trivandrum my initial years for conducting a domestic inquiry. It was about, this Akulam that converted this thing that later central government took over that scientific organization. Correct. That 22 witnesses were there. I remember still shuttling, to Trivandrum and then coming back in the late night trains. While I was traveling, I met one person who was a sales tax practitioner from Edapulli. He was going for something in Trivandrum. So I talked to him, he asked me for a visiting card. And then he started me giving a lot of work, just an incident. Coincident talking to a man in train. He had a lot of sales tax work. May not be too deep, but to start with, it was giving me good money also. Good work also, getting engagement every day. Getting engaged every day is something, you should all think of. Whether you go to Tahsildar or somebody, be engaged. That's something that give you a lot of confidence, for a forward career, and you will succeed ultimately due to those experiences you gain from lower people. Because they will be asking you to teach them. While I told that the opportunity means not before the High Court alone. Trial courts, before statutory authorities, before quasi-judicial functionaries, those are all opportunities. Don't hesitate to go there. You are getting experience. That is your earning, not money.
Thank you, sir.
Let me just make one addition. Opportunities, according to me, would come from various sources, some of which would be very, very, very different and never be expected at all. I'll just indicate one incident. Before I start practicing, I wrote one examination, one Public Service Commission examination. That was for selection to the post of Municipal Commissioner. Then it was the post of municipalities were heading by the commissioners, not secretaries. I wrote that examination, and during those days the results would come only after several years, and then I waited for some time. Then I was sure that that is not going to come through. Then I started practice. After about 3 years, when I was with Senior Advocate Sumar Nair, one person came to me. He said that, sir, you are selected as Municipal Commissioner and you are rank number 4. And first 3 persons have already been selected and appointed. And your turn is the next turn. And the list is going to expire tomorrow. Are you willing to join? I said, I didn't get any communication at all, sir. I have all the communication. Communication has gone to your house at Kollam. You didn't get it. You are here. I am the next person. And if you don't intend to join, I will get that job. You just give me a relinquishment letter. I had no reason to think otherwise. I immediately gave a relinquishment letter. Then I forgot about that. After about a month, he came back. He got appointment as commissioner in some municipality. Then, in his capacity as a commissioner, when he got the first notice from the High Court, he came to me. And that man was a problematic person. Wherever he would go, he would create some problem there, and he was subjected to frequent transfers. And in a span of about 7-8 years, he brought me about 100 briefs for different municipalities. So, very, and then ultimately, of course, he was suspended for some time. Then I had to conduct his case, and then it was like that. Hundreds of cases came to me through that particular person. Therefore, then another opportunity. Opportunity comes like that for lawyers, but you'll have to wait for the opportunity. You'll have to just be. You can't be impatient. You'll have to wait. When I started practice, my father was a lawyer for about 20 banks. And it was almost at the time when I shifted my practice, Debt Recovery Tribunal was established in Kochi for the first time. So when Debt Recovery Tribunal was established, all the banks for which my father was appearing, all those cases came to me. So this is by chance it will come for every lawyer, but you have to wait for the opportunity. Don't be frustrated. I would say that no lawyer has any reason to be frustrated. Opportunities are abundant. You have to wait for it. Be here. The work will come.
It's a good advice to write as many exams as you can and probably be willing to give up the post if you get near to the advice. I think this is informative, sir. In those years also this was happening for anybody who is appearing on the service side. Anyway, sir, Charlie sir, you were one person who has demonstrated amazing balance between your professional life and the work as a public figure, as a bar leader, as a person in public activities. How did you manage that balance? Because it's normally very difficult to have any co-curricular activity for a lawyer. So how did you balance that?
See, to be frank, after becoming president of this bar only I started speaking, public speaking. I'm telling you. See, I've not been active in school or in college, any of these activities, literary activities, or I did not have any oratory skill. After becoming president also, I was not, even though for 28 years I was very active at the bar. Each and every election I used to be very active, and I used to participate either for one of the candidates, And 29th year only, I have decided for various other reasons. I would say I was not interested personally. I used to be interested in helping people like who are standing as president or other committee members. See, I used to, be active in other areas also. Some sports activities were there. I used to go for morning basketball or shuttle or something like that. I was a hockey player. I was a university and state player in hockey, but after, my college days, I started playing something else. Shuttle or basketball, I used to go every day. Meticulously, I used to go that. Then go to the office by time. 8:30, I'll be there in office with my senior, as well as when I became independent. I used to be there in between 8 and 8:30. I used to be there. In between, I used to, drop children to school, and both of them were in Kakinada. I start early by 7:15 from home and drop them and come back to the office like that. It will come automatically. The balancing feature will come automatically if you are punctual. You must have decide what to do every day morning. If you have to drop the children, you will have to plan the time. 7:15 you will have to start, you will have to reach the such and such time will take, and come back to the office, and the kind of work you will have to do. You will have to meet client. If you say 8:30, I must tell you that you should be at 8:30, you should be in office. If you tell a client that you will be there at 8:30, his time, you should understand that his time is very valuable. Like your time, his time is also very valuable. So when you say 8:30 means you should be in office at 8:30. Punctuality gives you a lot of work. There's no doubt about it. And my experience is that if you are punctual, litigant is very sensitive. He finds that you are at office when he calls and you are attending his calls. That means he is 50%, 60% satisfied with what you do, and he knows that you are taking care of his work. So that balancing feature means if you are punctual, you will have a balanced life, definitely. Family also, sometimes I will say that I used to give, importance to the professional life, like everyone. And sometimes you will be late to the family. There will be small, problems will be there. But still, in your profession, you will have to be punctual. And family also, you will have to take care. I am not saying that. But I used to found very difficult to, be punctual with the family members because of professionally I gave importance to the profession. Some problems were there in the sense, you cannot attend the family like that. Otherwise, it was very balanced. If you are punctual, you can become very balanced in your everyday activities. There's no doubt about it.
So when Chali sir was speaking about punctuality, there are a lot of personal traits, personal behaviors, personal habits that contribute to becoming a better lawyer, better at the profession. What do you think are the things which positively impacted the habits and just like probably punctuality? What else?
I have not consciously developed any habit to sustain the work-life balance and all. But again, for me, as indicated, I was punctual. I've given due preference to I've given due value to the time of the clients that have given a sort of discipline also I followed, in the sense that I used to work early in the only thing when I do an introspection, what I find is that I used to wake up in the morning and do some work. The appointment. Now, otherwise there is nothing conscious about any discipline. I am not whether I am just not true. Maintain a sort of discipline, because otherwise I work, and therefore then I going to gym and then maintain some exercise. Friends to go to Delhi, I would have.
It is usually said that it is which contributes very substantially to your, that practically people opportunity.
I don't think that to become be super intellectual. Average person with hard work become a wonderful lawyer. That is options, but again, ignore them as try to build up confidence in you. Some would be best in delivering things. Some would be able people, and then if you work with average intelligence.
Suresh said that he started reading KLT years. So what is important is whether legal luminaries in Delhi, hard work only give you, whether That will not take you anywhere. There is no substitute. Argue a case properly. You should make up is going on. Big countries are there. Very small countries. We 100 the World Cup, but a small island World Cup. 130. Determination. And if you aim for it, you should remain 5 years, sit tight. What you come through. I'm a college, Ernakulam Law. We never used to enter the class. He said, hard work. You will all come up. Only thing is that wait.
You have practiced under the two seniors, one your father and the
നിയമം ഒരിക്കലും ക്ഷയിക്കുകയില്ല. ആ സ്റ്റാറ്റ്യൂട്ടിന് ഒരു റെമഡി ഉണ്ട്. അപ്പൊ ആ സ്റ്റാറ്റ്യൂട്ടിലൊക്കെ എന്തൊക്കെ നമ്മുടെ എന്താ ഇല്ലാതിരിക്കുന്നത് എന്തുകൊണ്ട്? Why? In 86, we used to go to them and introduce ourselves and so and so, and make. You will get lot of tips from that. That's something that's being lost. That's what I feel. Don't take, but make it a point that whenever you get an offer, you should go and talk to them, introduce to them, and meet them. That may take you somewhere else. You may scale in so that ensure that you meet people, you meet seniors, talk.
So your take will keep dear to you.
He prepares a matter. See, every paper that is entrusted to him, every paper. On the first day when I joined his office, that you will have to meticulously prepare that. Before you raise an argument in a court, sit in the arm as to whether you would accept this argument. He says that at least you must be in a position to be able to decide it. If you are able to create some confusion in the mind, then you are, and then sit in the armchair of the judge and decide as to whether you would accept it. Please do it from tomorrow onwards. Please argue only argument which, as a judge, you would accept. I would say you are halfway through. And one second thing I have seen in my life, another meticulous lawyer. I have learned many things. That is, most of you may know, he is Senior Advocate Chako George. Senior Advocate Chako George. He was a wonderful civil lawyer. I happened to meet him because my senior never used to come for trial. I had a few civil matters for trial, and then I had entrusted those matters to him, and then I was just preparing with him. You see, the meticulous preparation I have seen. That was, it was the file, even though the case was not having much stake, an autorsa load of documents I have given to him, because it was there are 100, I think about 560 or 570 documents had to be proved in the proceedings. Several witnesses had to be examined. He took 1.5 months to study. I still remember. I think his office is just St. Teresa's. 1.5 months to study. Every day morning I was sitting with him, and he has seen each and every document. Ultimately he said that he will not conduct this case because you are going to lose. He did not accept. After 1.5 months preparation, he did not accept it. And later days I have given so many matters to him, and I think meticulous way of doing things I have learned from him. Senior Advocate Chako George. I have not seen any other lawyer preparing to that extent in the High Court thereafter.
Now, one advice I have received from my senior is that if you feel that a particular argument is not very acceptable to you as a judge, then also you should raise it because you are not the judge yet.
you have
That's
to
why I raised those arguments.
you have to sustain as a lawyer. You have to see my point. I am just giving a tip to become successful. You can raise his argument. I myself said that I have diluted because otherwise your sustenance he is in trouble. Okay, fine.
Of course, both these seniors here, they were judges and they were beloved judges of the bar. But sir, was there a judge who terrified you?
When we came, if we look at us, myself and Suresh Kumar, how do you feel? Looking at us, whether you are terrified to argue before us?
There are judges who terrified you.
That's what I'm saying. Whether you are terrified to argue before us, you may say, somebody may say yes, or somebody may say no. But when we came in 86, the people who are sitting here is Justice Paribhurnan and Justice Paribhurnan and Justice Sukumar and Justice Bhatt. All those people, at least we should go prepared only. Otherwise, you are out. Justice Bhatt and all, if you go to that court without preparing, he will start asking you questions. From the first line itself, they will start asking you questions. If you are not prepared, then you will be ridiculed like anything, in the sense that to ensure that for the next case, you go before that judge after a meticulous preparation. I don't think that kind of terrifying situation is there. I have not seen after that. Those days it was like that. Only for this, nothing else.
And so your experience.
There were strict judges and liberal judges. I think that is in every court. In the corridors of Supreme Court, you would say that an acquittal judge, conviction judge, liberal judge, strict judge, all these fixations you will get it. But again, generally I have seen that some judges were very, very strict and very particular that the lawyers should study their brief and appear before them. You can just see that all throughout, if a judge is strict, all the lawyers will study and go. If the judge is liberal, you will take a chance. That is, you will certainly take a chance. If the judge is very, very strict and if you have not studied a brief, you will seek an adjournment. Am I not right? Am I not right? No, that's correct. That is all. I didn't find any judge as terrifying any lawyer. But again, judges would form opinions. Judges may sometimes reject your arguments and sometimes throw your brief away. Those things, according to me, we shall not take it seriously. I'll give you an example also. In those days when I was with my senior, every day evening after the court hours, we used to have a cup of tea together. And senior would be there and my colleagues would be there. One day my senior colleague, Justice Thodathil Radhakrishnan, told my senior, "Sir, I will not hereafter go before Justice K.G. Balakrishnan." Sir asked, "Why Radhakrishnan? What's the problem?" He doesn't like me. Simple reason, he doesn't like me. Sir asked, "Why? How do you say that he doesn't like you?" Yesterday he dismissed his case, today he dismissed one case. He doesn't like me. There's some problem. Then I still remember my senior told him, "Radhakrishnan, it is your impression about him. He wouldn't have thought like that at all. It is your impression. You are just deriving an impression that that judge does not like you. It is not correct. This is what I have learned from my career." After 2 days again, when we were having the evening tea, Radhakrishnan said that, "Sir, you said it is my impression. He dismissed another case also today." Sir said, "Okay, there is no change in my opinion. He has absolutely no problem with you. I believe that he has absolutely no problem with you. It is your creating impression. When a judge makes remarks, you think that the judge is against you. That is wrong. That is something which you shall never perceive at all." What happened after 3 days? After the 3 days, this man, this Justice K.G. Balakrishnan, became the executive chairman of the Indian Law Institute. And as executive chairman, he had to nominate one lawyer as the member of the Kerala chapter of the Indian Law Institute. And his first choice was Thottathil Radhakrishnan. So that, therefore, then what I learned from all these is that no judge is against any lawyer. Please don't assume that a judge is against you merely for the reason that 1 or 2 cases he decides. He believes that his decision is right. Then he'll have to do that. That is the oath that he has taken. That he'll have to do that. No terrifying lawyer, no lawyer who is not friendly with no terrifying judge, no judge who is not friendly with the bar. That is what I feel in my career. Nobody terrified me also, because I don't create an occasion for somebody to terrify me. I was very, very, very careful.
The next question was something like that, because has there been an embarrassing situation where you had a brush with a judge where you were a little embarrassed or you were a little unhappy, little down because of the response from the bench? I'm sorry.
Enough and more. But again, I had the advice of my senior. Don't take that into your head. So I just, when I come out of the courtroom, I ignore that. See, I was a judge here for 11 years. Now I am an ordinary lawyer before the Supreme Court. I am getting everyday basis all these. And if you just apply your ego, you are a judge of the Kerala High Court for about 12 years. And, I have, as a judge here, I have decided almost 300 preventive detention matters. And 2 weeks back, when I argued a preventive detention matter before that, the learned judge was teaching me what is preventive detention. He was teaching me. Now, I have decided hundreds of matters. You will have to accept it. When you are a lawyer, you will have to accept it. That is what I feel. Don't apply your ego then.
So your experience on that?
I did not have any bad experience at all, What I consider is, when the judge is asking a question when you are arguing a case, never take it negative. Because always judge, in a writ jurisdiction or sitting in High Court without looking into the oral evidence or whatever it is in an appeal matter, judge will ask you questions to elicit answers, to find out the truth. I remember Justice Raman is one such person, He used to, and then he wants to, see that whatever in his mind is received by him for the purpose of making a proper decision. So merely because a judge is asking question, and sometimes judges have a lot of tensions. That you should understand it practically. They will have to write judgments. They will have to prepare it. Before you start making your arguments, and so that lot of tension. So the question, or it may be little harsh. He may be asking you some question. That doesn't mean that is adverse to you. What he is asking for is to elicit answers from you and find out the truth or the legal reasons. That's all.
So one final question to both of you, because I want to throw it open to the floor. The question is this: how do you think technology is affecting the profession, and what is it, positive, negative, or something which is together, both?
Technology is not affecting the profession at all. According to me, technology will have to be, if it is properly adopted in the profession, and it will certainly enrich you. But again, one problem which I noticed, again I'll just give an example if time permits. About 12 years back, when I was occasionally attending Supreme Court, I had a matter. And on the previous day, I went to Delhi and sat in that court to watch what is happening in that court. Harish Salve was arguing a matter, and we started arguing. One of the judges who was there just indicated to him that he decided the point that was being canvassed by Harish Salve as the Chief Justice of the Bombay High Court. He said, I have decided this point against him. Fine. So then, if a large number of juniors were around him, that he have just shown some indication, go and search for that judgment. And then Harish Salve said, I will just answer that. Then he went on to the next point. And while he was just submitting the next point, in 2 minutes' time, the juniors came back and then gave the judgment. This is the advantage of technology. Which we were not enjoying at all. When we started practice in the late 80s, when our senior would require us to just to work out a proposition, we used to see all the books, all the manuals, all the digests, and then we also would go to the books, and then it will take several days to come to a point. But again, one advantage we had then was there is something called passive learning. Passive learning, the new generation lawyers are missing, that I have a feeling. When you just see hundreds of books and when you just look for a proposition, when you read the manuals, we read the digest, you learn many other things which would be useful to the next case that is coming to you. When the next case that when it comes before you, then you will have you are ready 50%, and only you need to put 50% effort. So that is also there. Therefore, advantages is also there, disadvantages is also there. But overall, according to me, advantage is more. Now, since I am asked this question, I like to say something about AI also. Now, for everything you have an answer. AI tool will give you an answer. Everything you can have study conversation also on a particular subject. Gemini, I was just indicating to HARIRAJ that Gemini permits you to have conversation also. You can have a lengthy conversation on a subject. You can have a debate, and it would reciprocate. Absolutely no doubt. But again, the point is that it will mislead also. Therefore, lawyers, according to me, will have to use this. I don't say the lawyers shall not avail this benefit at all. You will have to avail this. But again, it saves you a lot of time. Absolutely no doubt, it saves you a lot of time. But at the right point of time, you'll have to cross-check, because information sometimes or at times would be misinformation. So you'll have to just screen it. On the judicial side, this shall not be used at all. That according to me, because the human mind's intervention is required for the judicial decision, and the empathy and so many other factors which is required to be applied in the judicial decision process cannot be done by the technical tools. But again, lawyers can certainly use it. Use the technology, absolute no doubt. Now HARIRAJ is able to appear before Supreme Court because of the online facility. And am I not right? Because the online facility, in those days when we have a matter there, then you'll have to, previous day you'll have to go to the airport, stay there, be there for about 3 hours, then suddenly you will get a news that the flight is cancelled, then again you'll have to go to some Madras, then again catch another flight, then go to Delhi. By the time the case is adjourned. So many things. No, everything is there. You sitting at your home, you can participate. Of course, there are some limitations, a matter of appearing through online mode. But again, that facility is there. That facility enables a lot of lawyers to appear through online, making use of the technology. And I have seen lawyers running from one court to another court. And in between, if some case is called in some court, they will, in the corridors of Supreme Court, they are entering online and then making their submissions. Therefore, that thanks to technology, the technology certainly to be encouraged. No, absolute no doubt about it.
And sir, your take on technology side. Almost over, so we'll keep it as short as possible.
Time is almost 6 o'clock. See, my presence in the computerization committee was a strange coincidence, because 4 passionate persons about technology and this computerization was Justice Mustaq, Justice Jayasankar, Justice Raja and Justice Suresh. So after some meeting, they were standing near my chamber, after the meeting they were standing there. So I was talking to them when I came out of the chamber. Then Justice HRISHIKEsh Roy came out from his chamber to go home. Then he saw me talking to them. Next day I got a letter that you are also included in that committee. That's my association with the technology, but I was never against it. Whenever I got opportunity, I used to motivate the lawyers. Initially, there were a lot of troubles that to accept and adopt this technology, especially youngsters, as well as old people that was there. But we realized that it's very good for everyone. And I think in future, definitely the pendency now we are facing, that will come down considerably because of the technology. But one thing I pointed out to RUBEN and all when they came to, about 2 weeks back, 2 benches in Supreme Court decided on this one provision of specific relief act 28(3), whether an extension can be granted to execute a decree after the period fixed by the court. One bench said it cannot be done. If an extension is to be sought, it will have to be sought within the time period fixed by the court. Then another bench said, almost on the same day, that it can be extended even after expiry of the time. 2 propositions from 2 benches on the same day. How to cope up with it, you will have to discuss in one of these meetings, Using this AI or whatever technology we are now having, advanced technologies we are having. Anyway, thank you for this. Now,
Thank you, sir. Yes, I am strongly instructed to go for a rapid fire round. Sir, the rapid fire round. Because it is to be rapid, you can have the mic ready. I only want one word answers. Physical hearing or virtual hearing?
Physical hearing.
Arguing a case or writing a judgment?
Writing a judgment.
Morning preparation, late night preparation?
Morning preparation.
Strict judge, lenient judge?
Strict judge.
So for you, Supreme Court or High Court as lawyer?
High Court, definitely.
Junior or research assistant?
Junior.
One brilliant argument or 10 hours of preparation?
One brilliant argument.
Reading facts or reading law?
Reading facts.
Wonderful. So that is the rapid fire round. I hope that was, I think that we will wind up my interventions here. We'll leave the room open for questions. We will take 15 minutes of time and wind up our program. So any questions from the floor? To them.
So, is there any unforgettable case in which you started arguing and the judge wasn't in your favor, then after a long haul, you got to get him back to what you want? To both of the guests. Do you recollect any of such cases? There would be many, but
There are hundreds of
yeah, any one memory of it.
I don't exactly remember. There are hundreds. After 4 days of persuasion, some judges turn to your side. After 4 days of preparation, there are hundreds of cases.
To both judges.
See, when you are confronted with a question, sometimes you may not be able to answer on the same day, but you can still ask for time. And try to persuade the judge. Persuasion is something which is a skill which you will have to employ. That's a tool to be employed to persuade the judges, to drive home your points. Only thing is that while doing that, you should confine yourself to that point. Don't go here and there. And persuasion is one of the skills you should acquire in order to drive home your points and attain your goal. There's no doubt about it.
Hello, sir. Both of you can answer to this question. So, when we have to prepare for hours and hours, and the traditional practice demands our time from morning to evening and night, and one day is not enough. 24 hours certainly does not feel enough so many times, and how to cope up with the stress, and there's lot of mental health discussions are going on in the profession. Is there anything that you actually took care to keep your stress free, or you did not worry about it at all? Is it something new that has come up and we should find our own way? How is it?
There is an autobiography written by former Chief Justice of the Bombay High Court, M.C. Chigla. He used to say in his book, and he has said in his book, that he was a Chief Justice of the Bombay High Court for 14 years, and he did not reserve a single case. All the 14 years, all the matters he decided, he dictated in open court. Fine. And he has said that he has taken only the draft of the dictation to his home for correction. You can just read that book that is there. But Roses in December, that stage is over. In those days, only 1 or 2 matters were listed for hearing in courts. And all the lawyers go to the court with meticulous preparation. Things have changed. Now 200 to 300 matters are listed in every court. I was sitting here and dealing with miscellaneous matters about 3, and one day total number of admissions was 300 because some other judge was not sitting. Those matters also came. So then you are under pressure. You want to clear the board, because what you think is that at the bottom of the list there is some matter which is very urgent. Something will happen to that matter today. It will become infectious tomorrow. Therefore, then you have to clear the list. That it is under that pressure the judges are hearing the matter and taking up the matter. Then the judges want you to be meticulously prepared. If a question is put, you are not giving the real answer, the judge would become impatient. Then you will have the tendency to adjourn it. So you will have to cope up with the work. Because the changing times, you will have to cope up with the work. Supreme Court, no, I just because you have indicated this, no, the Supreme Court situation, I was just sharing my views on that. Earlier days when I was there in Supreme Court, Mondays and Fridays exclusively miscellaneous matters. Tuesday after notice matters. Wednesday and Thursday final hearing matters were being taken up. Now the things have gone completely. There is a computer listing. In the computer, if you show, there will be 100 cases listed. None of the matters will be actually listed on the 11th day. On the 11th day, some other new matter will come. And every day, hundreds of miscellaneous matters are being listed. Even if it is not likely to be taken. Therefore, probably Supreme Court is also working under pressure. You know what, the change they brought was they have started listing transfer matters and liberty matters in all the days. If you ask me the question as to question whether should it be given some preference, of course it will have to be given some preference. But again, that changes the whole system. So the courts, those days, everybody had the time to prepare because everybody had only limited number of cases. Now, when I started practice here, the total number of writ petitions were less than 10,000. Now it is almost 1 lakh. Almost 1 lakh. It appears that last year it was 99,000 odd, 98,000 odd. So then we'll have to cope up with the work. You will have to devote more time. What the only option is, don't take up large number of cases which you cannot afford. To find time. Take up minimum number of cases, do 100% of those cases, then go to the court meticulously so that you must be in a position to give the reply to every question that is coming up. The stress is created by you. According to me, stress is created by you. When you take up more number of matters, you are not able to find time, then that is not the fault of the court. That is my simple answer. I don't know, Justice Tally would agree with me or not.
See, Maitreyi, you were asking for the leisure also, you know. How do you find leisure? See, I'll tell you, like I said, definitely you should have leisure time. That's why I tell you, you should engage, in some activity in the morning. That will give you a lot of impetus, for your day's work. You should definitely work leisurely, I would say. That, why I say that is, I told you earlier that if you are punctual, you should decide that yourself, you should do this. You cannot wait because your client is a sensitive, litigant is always sensitive. So you will have to find time to prepare his litigation. But at the same time, you will have to look at your health, otherwise you cannot work. If you want to work, you should have some leisure. So find leisure. If you read, just Suresh said this Roses in December by Chagla, it's a book to read. But he has told in that how to enjoy life also. After meticulous preparation, he said, from Monday we are starting that, Friday evening is the to enjoy in the club. If you read that, you will get that. That's how you will have to enjoy life also. For that, you will have to be meticulous.
Play. You'll go to the club for play bridge.
And at those times, they used to go to the club with lawyers. He has written that lawyers used to host parties for the judges also. But that has nothing to do with the judgments. That's the way the relationship was maintained with the bar. Here, if we go for a marriage, next day it is there in the, one of the social platforms, that man has attended the lawyer's wedding and he has taken a photograph with the bride and groom. Is it justified? Though these kind of things, will not help you. You should go for leisure, but that has nothing to do with the judge is always independent, impartial. He may decide against you, but that doesn't mean that he is not impartial. He's not partial. That's what I'm saying. Find some time.
One thing more I would add. Now you should learn to manage your work also. That is also very important. Nowadays, people are interested in conducting cases. Okay, fine, making money, everything. But again, you at the same time, you have to manage your work also. This management gives you this pressure. If you don't properly manage your work, it automatically gives pressure. You may not be able to deliver the product. You may not be able to prepare well. But again, if you manage, and if you are not in station for 2 weeks, you have to just see as to whether any of the matters are coming, and if those matters are coming, make some alternate arrangement. If you properly manage, I don't think that it is a big pressure for you to be too much worried about this. You can manage. Anybody can manage. That is what I have seen. I will tell you one example also. When I started practice in my father's office, ഒരു ബുക്കുണ്ട്, കുട്ടി ബുക്ക് എന്നാണ് പറയുന്നത്. കുട്ടി ബുക്കിനകത്താണ് ദാറ്റ് വി ഓരോ ദിവസത്തെ പോസ്റ്റിംഗ് എഴുതുന്നത്. ഒരു ദിവസം 300 കേസ് ഞാൻ കണ്ടിട്ടുണ്ട് അവിടെ. മൈ ഫാദർ സിംപ്ലി സിറ്റ്സ് അറ്റ് ഹോം. ഈ 300 കേസിൽ ഒരു കേസ് പോലും ഡിഫോൾട്ടിന് തള്ളത്തില്ല. ബിക്കോസ് ദർ ഇസ് എ സിസ്റ്റം ഇൻ പ്ലേസ്. ഫൈൻ. എൻ്റെ കൂടെ I had a colleague. He was with me for about 7 years. He had some personal matters. ഒരു പേഴ്സണൽ മാറ്റർ, only few personal matters, 5-6 മാറ്ററേ ഉള്ളൂ. അതിൽ ഒരു മാറ്റർ he wanted me to argue. സീരിയസ് മാറ്റർ. അപ്പോൾ ഞാൻ ആ ആർഗ്യാൻ വേണ്ടി പ്രിപ്പയർ ചെയ്തപ്പോൾ കണ്ട കാര്യം വെച്ചാൽ അതൊരു സൂട്ടാണ്. ഐ വാസ് സപ്പോസ് ടു ഗോ ആൻഡ് ആർഗ്യൂ ബിഫോർ ദി സബ് കോർട്ട് എറണാകുളം. ആ സൂട്ട് 9 പ്രാവശ്യം ഡിഫോൾട്ട് തള്ളിയിട്ടുണ്ട്. 9 പ്രാവശ്യം ഡിഫോൾട്ടിന് തള്ളിയിട്ടുണ്ട്. അയാൾക്ക് ആകെ 5 കേസേ ഉള്ളേ. അപ്പോൾ എവിടെ പ്രോബ്ലം എവിടെയാണ്? നമുക്കാണ്. യു ഹാവ് ടു മാനേജ്. റെസ്പോൺസിബിൾ ആയിട്ട് മാനേജ് ചെയ്യും എന്നുള്ളത് പാർട്ട് ഓഫ് ദി വർക്കാണ്. യു ഹാവ് ടു മാനേജ്. ഇഫ് യു ആർ ഏബിൾ ടു മാനേജ്, സ്ട്രെസ് വിൽ ഗോ.
This question is to Charlie, sir. Sir, you mentioned that in the beginning of your career, you practiced across various forums, but today you are confined to practicing before a single forum. So if you were to compare the two lawyers that you were before and today, and you had to name one advantage or disadvantage, what are they?
In Supreme Court, you mean?
Yes.
See, in Supreme Court, you will find that, very meticulous and efficient lawyers. But that's only a set, maybe 100. Thousands of lawyers are coming to Supreme Court. But maybe 100 or 200 will be excellent, you can say. All others are studying and coming and conducting cases. But that doesn't mean that they are all, very superior to the other lawyers here. You are all very bright and brilliant. Only thing is that you are not got an opportunity in the Supreme Court to argue your matter. You know, here also you are getting opportunity. You are arguing matters. The forum doesn't matter whether you appear before some district judge or a municip or some quasi-judicial functionary. That doesn't matter. You know, you should prepare and you should argue, which impresses the judge or authority or adjudicating authority. That gives you a lot of impetus to take your profession forward.
We'll take 2 more questions and call it a day.
As advocates, we constantly observe judges to understand their temperament, how they are going to judge a case, especially on the particular day when we are having postings and all. And you both have experience of watching the bar from the bench here, and now you are having the experience of watching the judges in Supreme Court from the bar. So what differences you feel, how, like, can both of you please explain, tell us your perspectives on this matter?
In the Supreme Court practice, in the Supreme Court, the considerations are totally different. Considerations are totally different in the sense, it may not always be legal. I don't know whether I can say that. It may not always be legal. In the sense, I've, for the last 1 year, from my experience during the last 1 year, generally if you say that all good cases have gone, all bad cases have gone inside, generally we can say. But when you just do an introspection, what I find is that for every case that is lost, there is a good reason. There is a good reason. But as lawyers, you may not see that. As lawyers, you may not see that. Since I had this experience as a judge also for about 11 years, and I can understand it. I can understand it. Say, for instance, we were just sharing the same thing. ഒരു സെക്കൻഡ് അപ്പീൽ മേലുള്ള SLP സുപ്രീം കോർട്ടിൽ വരുമ്പോൾ ചിലപ്പോൾ ആ കയ്യാലപ്പുറത്ത് ആഞ്ഞിലി ആയിരിക്കും അതിൻ്റെ സബ്ജക്ട് മാറ്റർ ഓഫ് ഡിസ്പ്യൂട്ട്. യു മേ ഹാവ് എ വണ്ടർഫുൾ പോയിന്റ്, CPCയിൽ ഏതെങ്കിലും പോയിന്റ് ഡയറക്റ്റ് ആയിട്ടുള്ളൊരു പോയിന്റ് ഒക്കെ ഉണ്ടാവും. ബട്ട് അവർ ചിന്തിക്കുന്നത് അതല്ല. അവർ ചിന്തിക്കുന്നത് ഇത് ഈ ആഞ്ഞിലി ട്രീയിൽ ടു എൻഡ് അറ്റ് ദിസ് ഹൈക്കോർട്ട് ലെവൽ. ദാറ്റ് ഈസ് ദ കൺസിഡറേഷൻ. But then there is no reason to be frustrated, there is no reason to be worried. According to me, that is the fate of that case. You'll have to accept it. You should have the mindset to accept it. Again, then technical points, at times I find that technical points is not working there at all. In every case, you should have some equitable entitlement also you'll have to show. With equitable entitlement, it is very, very difficult to get relief there. You may have a wonderful point. So, think different. It is a totally different ball game there. Then they have also this pressure. If all the matters are admitted, all the matters are required, there are hundreds of, there are a lot of debates going on. That should the Supreme Court decide all these matters like that? No, there are a strong view among the public that Supreme Court will have to just be a referral court. അങ്ങനെ ഒരു സീരിയസ് തിങ്കിങ് ഡിബേറ്റ്സ് ഒക്കെ നടന്നുകൊണ്ടിരിക്കുന്ന ഒരു കാലഘട്ടമാണ്. അപ്പോൾ therefore അതെല്ലാം അവരെ ഇൻഫ്ലുവൻസ് ചെയ്യുന്നുണ്ട്. അപ്പോൾ അവർ എല്ലാ കേസും അഡ്മിറ്റ് ചെയ്യത്തില്ല. ഇൻ എവറി കേസ് ചിലപ്പോൾ നമുക്ക് തോന്നും വളരെ മോശപ്പെട്ടൊരു കേസാണല്ലോ സുപ്രീം കോടതി അഡ്മിറ്റ് ചെയ്തിരിക്കുന്നവർ, നമുക്ക് നോട്ടീസ് കിട്ടും, റെസ്പോൺസ് ആയിട്ട് നോട്ടീസ് നമുക്ക് തോന്നും. ബട്ട് അഗൈൻ ഞാൻ അത്തരം കേസുകളൊക്കെ നോക്കുമ്പം ഞാൻ അതിനകത്ത് കാണുന്നതെന്ന് വെച്ചാൽ അതിനകത്തൊരു ആ പെറ്റീഷണറുടെ സൈഡിൽ ഒരു ഇക്വിറ്റബിൾ റിലീഫിൻ്റെ ഒരു എൻറ്റൈറ്റിൽമെൻറ്റ് ഉണ്ടെന്ന് എനിക്ക് തോന്നാറുണ്ട്. അതുകൊണ്ട് ഇപ്പം അത് ഇനീഷ്യലി എനിക്കും ഒരു 12 വർഷത്തെ ഇടവേളയ്ക്ക് ശേഷം കൊണ്ട് പോയപ്പോഴത്തേക്ക് ഓൾസോ ഒരു കേസ് നോക്കുമ്പോൾ ഒരു ഭയങ്കര സങ്കടമൊക്കെ ആയിരുന്നു. ഇപ്പം ഐ സ്റ്റാർട്ടഡ് അക്സെപ്റ്റിംഗ് ഇറ്റ്. I will find one reason to justify the decision of Supreme Court. Therefore, practice there is different. Practice here is different. Practice here, if you have a legal point to raise it, you will have to succeed. Fine.
I fully agree with Suresh Kumar. I'll be very brief. That the practice is entirely different. You are getting, sufficient opportunity to explain your facts, your law, everything. Then what I find is that brief facts which will click immediately and the law on the point. Sometimes if you explain the facts and law 100% in your favor, still your petition will be dismissed. One case I remember, one criminal matter I went, 100% I said it's a good case. It was dismissed from here and brought from the discharge application it came before I felt that was a 100% good case. I directly showed a Supreme Court judgment which says that under the CRPC, no vicarious liability can be fixed against an accused. Still it was dismissed. But I would say that dismissal was good for the client because in 2 months on the same decision he was acquitted by the trial court. If it was admitted and, after some time the judge may come also the same thing, nothing in it, you will have to face a trial. In 1.5 months or 2 months, he was acquitted. Like that, both are different, as my friend Mr. Suresh said.
We'll take one last question.
First of all, thank you so much for Wednesday Club for organizing this event. It was an eye-opening session and insightful. It's not something that I'm formally saying, it's not formal praises, but it is something which is from my heart. So I'm a very recent enrolled advocate in 2025 October, and I have seen my peers moving to corporate law firms or corporate or companies. And one of the concerns that they have raised is lack of motivation. Sometimes you will have 3 to 4 days or a week going blank. So as former judges and experienced lawyers, more than that, what is a kind of advice that you can give to, even though motivation is not something, sometimes there will be no motivation, it is sheer discipline and hard work. So what is a kind of artificial motivation that you can give us to bring up that motivation?
Give preference to your passion. Give preference to your passion. If you're passionate to practice before the court and litigation is if the litigation is your preference, prefer that. There are a lot of people who do not like to be there in the court halls. They want a comfortable job, 10 to 5 job in a law firm. There are hundreds of people working, making a lot of money than the people who are there in the court among the junior lawyers. But at the same time, I have seen a lot of junior lawyers who are working in firms, in various firms in Gurgaon. I have seen that. I can just quote 1 or 2 examples also. They've come to me and they said that they are very much worried. It's monotonous work and I just wanted to come to the court. I've cautioned them saying that this is not very easy. If only you are that passionate, if only you are that confident to come to this, otherwise the other thing is good. But again, ultimately there are 2 choices. And if a choice is to be a peaceful work culture, go with a firm. A lot of work, same work is being carried on there also. But again, they are not exposed to the court work. That is all the difference. The rest are the same. They are not exposed. I know a lot of people who work in various firms. They are equally efficient. They are equally resourceful, and I've seen, I used to contact a few friends there also, equally resourceful, but they, at the same time, they are lacking the court work. But at the same time, when you come to the court, then you are losing that, and you will automatically learn the court skills, that's all. But again, which is your passion? Give preference to your passion. If you like to be a good lawyer and you want to be a lawyer in the court, then come to the court. Otherwise, be happy with the firm work. That is my humble view.
Yes, thank you so much.
See, I'll first of all, I will confess that when my younger daughter joined the profession, she is in Bangalore, so she started in a firm. So my first advice was ask for litigation wing. I don't know, I cannot agree with that, you go and sit before a computer and do your work all throughout. I was always passionate with work and examination of witnesses and all those things. As Suresh said, it depends on your, attitude and nature. Which one you want? You want to make money? Or you want to be a good lawyer coming to court and then, examining witnesses, cross-examining witnesses. It depends on your nature and attitude. Ultimately, if you want to come to the court and, demonstrate yourself as a good lawyer, then you should develop that passion. Forget about the money. The money we used to get, I used to get in a month when I started was 500 rupees maybe. 500 rupees, I am telling you the truth. But if you go to a corporate firm, you may be getting 2 lakhs. But ultimately, as Suresh said, after 5 years, if she was not passionate with that kind of work, she may come back disheartened. But first of all, you should decide what you should have. The satisfaction of being a lawyer, coming to court every day and practice, or else to make money.
Thank you, Suresh sir, Charlie sir, for being here with us, and thank you all for being such a wonderful audience. I think what we take home today is that the success in this field, in our career, does not depend so much upon where you come from and what you bring in, but what you persevere, you have patience, you should work hard, and above all, you should follow your passion. The last question, and passion is all that keeps us ticking in this profession, is what I feel. I think, and as far as Maitreyi's question of stress is concerned, I think we have to help each other. That's one thing that I would like to add to what Sir said. We need to help each other. I think what brings me back to the court every day is not just the court hall, it is also the corridor. And that is where the stress gets diffused. And that's what keeps us ticking. And that's the only way I think we can cope with this mechanism of stress. There will be stress. There is no question of not being stressed. We are all stressed, and certainly now I am thinking about what would be the list tomorrow. But at the end of the day, that is there still. And being punctual, all those lessons which you heard from the stalwarts today, please take it home with you. Keep it in mind. Let us have more of these kind of interactions with more people like as experienced as our guest today. And I should also thank Wednesday Club for choosing me to be on this chair today. Thank you so much, and thank you so much for that notes. The cross-examination would not have been as effective had it not been for the notes from Maitreyi and CHELSON. Thank you so much, and thank you so much everybody else also who have made this event so meaningful.
So I hope all of us had a very inspiring session, exciting session, and we can take home some advices from our guests, especially to have problematic clients who brings us more clients, and not just Suresh Kumar sir and Charlie sir, but HARIRAJ sir also gave us very valid inputs. So thank you, all three of you. And now I invite CHELSON to deliver the vote of thanks.
Respected judges, senior advocates, and esteemed members of the KHCAA and the club. First and foremost, it is an absolute thrill to have you both, sirs, in this premises and in this association hall. It is a deja vu, and we sincerely thank you for accepting our invitation and presiding over this function. I express my sincere gratitude to Senior Advocate HARIRAJ sir, who is no stranger to us. He has been very much our all-rounder and all-runner so far for the Wednesday Club. He has been much of a support, and he has agreed to chair this as the moderator without any second thought. So thank you, sirs. At the outset, what was a biggest takeaway through this session was how two divergent roads have made a mark. They have both excelled in their own distinguished ways and have made a substantial mark both with their presence in the bench as well as their ongoing presence in the bar. So our biggest takeaway would be, sirs, is that all roads lead to Rome, especially if it is followed by sincerity, dedication, and grit. Thank you, sirs. On behalf of the club, I express my sincere gratitude to the KHCAA for their continued support to the club. And one big takeaway from this program would be the importance having or bringing back the ritual of maybe organizing some parties for the judges that you can volunteer to set up. So thank you, KHCAA. Advocate Biji is here representing the KHCAA, and President Piyush Kattam sir was also here earlier. So thank you all from the association. Finally, I would like to thank each one of you for your valuable and very important presence on this Thursday for our Wednesday. So thank you all. Meeting dispersed.